I'm just checking here before I get us kicked off and going. I don't know about you guys. I think my microphone's actually. Oh, interesting. Just 1 second, Mike. I might have to leave and come back to you, okay?
Okay.
Ha, okay, that's perfect. Sorry about that. I noticed my microphone was unplugged, so I was trying to get that back going.
Not a problem.
Okay, so let me finish sharing this out. For those of you that are already starting to tune in, please do us the favor of giving me a thumbs up and start commenting so I know who you are and can reference you in the starting comments of this broadcast. Thank you for your patience. Okay. Awesome. All right, so I see Parker Brown and a couple of others that are on here, so we'll go ahead and get started. Good morning to you all, and it took me a second to think about what day it is because it's so gloomy out there. I felt like it was Friday. So happy Tuesday to you. Thank you for hopping onto our broadcast with us. Most of you should know me by now. I am Juliet Abdel, President and CEO of the Westminster Chamber of Commerce. If this is your first time on our page, please do not let it be the last. Make sure you hit the like button, hit the follow so you can get those alerts when we do go live or post fresh content. At the same time that we are streaming this on our Facebook channel, we also have it on our YouTube page. That's Westminster Chamber of Commerce. And if you haven't already connected with us on all of our social platforms, I highly encourage it at Westy Chamber on Twitter and Instagram, and of course on LinkedIn, Westminster Chamber of Commerce. Now, most of these videos are available to you in the video section of this broadcast. You can also find it on our website, westminsterchamber.biz, and just decide to binge watch any of the weekends, even Thanksgiving week. If you want to get away from family, we will be your outlet at any point in time. Make sure you give us that hashtag replay if you do rewatch something that's from a while ago, as we like to know which of the content you found the most valuable. Now, today's broadcast, I do have with me Mike Lazar. You've met Mike a couple of times when I've had him on here sharing some updates as it related to reopening our businesses, some of the best practices that were available. Mike is the general counsel to the Westminster Chamber. He is also a founding member of the Chamber and a member under his company. So his company he's affiliated with Feldman, Nagel, and Catafio. And this is a side note, Mike. I was going out to Boulder the other day. It was yesterday because I had this package coming in. The shipper wrote my address wrong, so they put my zip code as 80305 instead of 80035. So I'm heading out to Boulder. I'm at this stoplight, and I turn to my right, and I see this big sign, and it's the branch of your law firm right there on the corner. So I took a photo of it. I'll be sending it to you here later on. But Mike actually generally works in the Denver location. Obviously, with COVID, there's a little bit of a combination of that being home and being there in person. So as you're hopping into this broadcast, please do us a favor by commenting into the live feed section. As I see Chip House is already done. Use this for good morning notes, any compliments, comments that you might have, or any questions that you feel you want to field over to Mike. It can be related to the content that he shares. It could be just in general that you feel like he might be able to answer and assist you. But today's broadcast is really dedicated toward our paid family medical leave. As many of you are aware, this just passed in the last couple of weeks after our election. And so Mike has taken the time to pick this apart and kind of look at how can we understand it more as a business community and be prepared for it. So with that, Mike, thank you for your patience as I adjusted everything and was introducing a couple of folks. I will go ahead and mute myself and you can take it over.
All right, thank you, Juliet. So as Juliet mentioned, I'm Mike Lazar. I am an attorney with the firm of Feldman, Nagel, Catafneo & Song. She forgot the latest partner that was added. I'm head of the civil litigation practice group at the firm. My office is down in Denver. So I'm, leading, I don't know, half a dozen or so trial attorneys through various civil litigation affairs. And we do everything from breach of contract disputes, ownership disputes among companies. We do malpractice disputes among professionals, a lot of fun stuff and things like that. My practice also includes serving as outside general counsel for a number of businesses that don't have their own in-house counsel. And in that role, I'm just there to keep people out of trouble. For most of you, your job is not litigating things and not being in lawsuits with employees or partners or vendors and things like that. So my job is to help you stay out of that and keep you focused on things that actually make you money. Just briefly about my firm. So as Juliet mentioned, we have offices down in Lodo, and we also have an office in Boulder. We have roughly 30 attorneys spread around the country, and we're a full service firm. So we have attorneys that practice in most areas. I think there are a couple, very niche things that we don't have, say like securities law or something like that. But, for litigation needs, for transactional needs, bankruptcy needs, domestic needs, we check all those boxes pretty well. So if any of y'all ever need something, please reach out to me and I'll see what I can do to help. All right, so today we're going to be talking about the Colorado Paid Family and Medical Leave Insurance Act. So if Juliet could pull up the slideshow. All right, here we go. All right, so let's go to the next slide. And that's a little bit about me. We'll skip that because I just went through that. Next one. All right, so what is the Paid Family and Medical Leave Insurance Act? This was Prop 118. We just voted on it in the election. The important things that businesses need to know is when it's going to take effect and how it takes effect. So it's a self-executing statute. It'll take effect upon declaration of Governor Polis. There are two big deadlines that y'all need to understand. One is January 1st, 2023, and the second is January 1st, 2024. So if you read the statute, what the statute states is that the Paid Family Medical Leave Act will take effect the program will be administratively defined and begin collecting premiums in 2023, and then benefits will become available for payees into the program beginning January 1st, 2024. The only thing that I'll note here is there seems to be a little bit of a confusion within the statute itself. I noticed that one of the statutory provisions stated that by January 1st, 2023, that premiums would be collected and everything would be administratively defined. And then there's another statute that says starting that date that premiums will be collected. So I would simply presume if I were businesses that you need to have a plan in place for the premiums beginning January 1st, 2023. If y'all want to take a look at the statute itself, you can find it at Colorado Revised Statute section 8-13.3-401, and then all of the subsequent sections there. So let's move on to the next slide. So generally speaking, the Paid Family Leave Act mandates that all employers in Colorado create and provide paid leave programs for their employees. There are a couple of different ways that this can work. Employers will be able to create plans through private means, or they can opt into the state-provided plan. I'm going to spend most of today talking about the state-provided plan, just because I think that'll be most applicable to most Westminster businesses. I will touch on the private plans briefly later on. With regards to the public option, if you will, think of it as working very similarly to the Affordable Care Act. This is basically an insurance plan. Employees and businesses will contribute premiums to the funding of the plan, and then from the fund, benefits will be paid out to employees who need to take paid leave. So next slide. All right, so who's subject to the Paid Family Leave Act? Well, the answer is basically everybody. First and foremost, all employers are subject to the plan. And I put that term employers, and there are going to be other terms that you see in this slideshow that are terms of art within the statute in quotes. And I put them in quotes just to flag that they are terms of art and they have separate definitions. I'll focus on the definition of employers here shortly, but I just want to flag that issue for you. So everyone who employs someone is subject to the Paid Leave Act and is required to provide these benefits to his or her employees. Self-employed persons are generally not subject to the Paid Leave Act. However, they may opt into it. However, if they opt into it, they have to opt into it for a period of at least 3 years. And then the last set of people who may be subject to it would be local government employers. And I put a maybe there, and the reason why is because the statute's a little bit vague with regards to what the requirements of local governments are to opt into the program and what they'll be required to do under this act. Generally speaking, the state doesn't want to mess with the municipal governments, the local government offices and things like that. So there is going to be some kind of option, I think, for local governments to opt in or opt out, and this will all be subject to regulations later on. And actually, that's an important point I want to stress real fast, and I mentioned this on one of the previous slides, is that what this statute is, first and foremost, is kind of the outer skeleton of the paid leave program. It's going to change quite a bit over the next couple of years as the new state agency that's being created creates the rules and regulations that will actually handle the administration of the program. So what I'm talking about today is the statute itself. What you need to keep in mind is that there's going to be a lot of other regulations that are passed that will have the same force of law that will flesh out a lot of these concepts today and potentially change what this program means for businesses later on. All right. So with that said, next slide. So employers, who are employers? An employer is any person engaged in commerce or an industry or activity affecting commerce that employs at least one person for each working day during each of 20 or more calendar work weeks in the current or immediate preceding calendar year, or has paid wages of $1,500 or more during any calendar quarter in the preceding calendar year. Now, here's the big takeaway from this. If you are a small business owner and you're paying anything to anybody, you need to think very long and hard about whether you're subject to the Paid Family Leave Act. Now, if you're paying contractors to come in and go do things, and you're 100% sure that they're contractors and 1099 workers as opposed to actual employees, you're okay here. But if you have people who are regularly working for you who may fall under the definition of an employee, and again, this is a sometimes difficult concept under the law, something that's litigated very frequently and sometimes very, very fiercely. You may be on the hook for paying benefits here when you don't even know it or not even expecting it. So be careful with this. The other thing that I want to point out with this definition is the definition of wages here. The Paid Family Leave Act does not define wages separately, but wages is defined in other Colorado statutes, namely the Colorado Wage Act. And you'll find the Colorado Wage Act at Colorado Revised Statute 8-4-101 at SEC. And I believe it's in subsection 14A that you'll find a definition of wages there. And wages doesn't just mean the wages that are paid or the salary that's paid. It's very broadly defined to include pretty much any kind of compensation or benefit, with the exception of severance pay. It's more complicated than that, but that's kind of a good working definition that I think businesses can wrap their heads around. And so what am I talking about there? That's going to include bonuses. It's going to include wages and salary. It's going to include commissions. It'll include pay time off benefits and things like that. It's an incredibly broad definition. So it's going to be very easy for employers to hit that $1,500 threshold in any given quarter. So next slide. Now, employer also has a couple other definitions under the statute. And the first is a person who acts directly or indirectly in the interest of an employer with regard to any of the employees of the employer. Now, this is an odd definition here because it's rather circular. I mean, why is the definition of employer or why is employer showing up in the definition of employer? The way that I'm reading this is that this may create separate individual liability for persons within companies who are in charge of managing employees. It's not entirely clear what this means, and so I'm flagging this for something for employers to be aware of. And the point that I want to make here is that any given small business or business for that matter wants to make sure that they dot their I's and cross their T's with regards to their obligations under this act, because this provision here may create some kind of individual liability, and I wouldn't be surprised to see some lawsuits on this point in the future. The other provision to be aware of is the definition of employer also includes a successor in interest of an employer that acquires all of the organization, trade, or business, or substantially all of the assets of one or more of the employers. So what does this mean? This is the situation that occurs whenever someone buys another business out and buys out its operations. So when I read this statute, the way I see it is that if you go and you buy some other business and that other business has flubbed their obligations under the Paid Leave Act, you might be responsible for those obligations later on, as opposed to the former employer. Maybe that both of you are responsible for that. So the practice pointer here for businesses, and really this is something you should chat with attorneys about, this is something that attorneys need to be aware of, is that in any kind of M&A transaction, so a mergers and acquisition transaction, the buying out of businesses or their assets, the businesses involved need to make sure that they are fully disclosing what's going on with their employees and compliance with the Paid Family Leave Act. Otherwise, you're going to have a bunch of ugly lawsuits later on, breach of warranties, other things. All right, next slide. So as I mentioned earlier, employees can meet their obligations under the Paid Family Leave Act if they apply to the division for approval of a private plan. This is mostly going to apply to the very large corporate employers in the state. I think like the big multinational corporations, plus any other business entity that has self-funded benefits for the employees. And what I mean by self-funded is think of like in the context of healthcare benefits and things like that. A lot of employers, for the sake of getting the most bang for their buck, actually fund the payment of medical benefits for their employees rather than just paying for insurance to provide medical insurance for their employees. And then what they do is they hire the insurance companies to come in and administer the plans. What Paid Family Leave Act does is it allows employers to do something similar here in Colorado with their paid family leave obligations. And in fact, a lot of major employers and large corporate employers already have leave policies like this in place. And so what this slide does is kind of summarizes the procedure for getting a private plan approved. All right, next slide. So here's the big question on everyone's mind. Who is entitled to paid family leave benefits? And so this is probably the most important slide in the presentation, and we're going to be diving into a lot of this stuff in a little more detail here. But definitely take notes on this one. So here are the people who get to take leave under the Act. First, the employee has to be a quote unquote covered individual, and I'm going to go into that. And then beyond that, beyond being a covered individual, the employee also has to meet one of the following requirements. And that is they either have to be taking leave for the purpose of dealing with a new child in the family. And this includes new child through adoption, through foster placement, or through natural birth. I mean, this is very broadly defined. The second option is the person is caring for a quote unquote family member with a serious health condition. And we'll talk about what serious health condition is shortly. The employee has a serious health condition. The next thing would be the employee has a qualifying exigency leave. Again, we'll talk about that one. And then the last option is the employee has a need for quote unquote safe leave. We'll talk about that as well. So next slide, let's talk about who covered individuals are. Covered individuals are people who meet the quote unquote earnings requirements. And again, we're going to define this further. Meet specified administrative requirements, and then submits an application to the division with a claim for benefits. So let me focus on the second two things first, just because those are very easy to talk about. The administrative requirements are yet to be defined. Remember earlier I was talking about how the new state agency is going to come in and define all this stuff further for, with regulations and things like that. And so what I think the administrative requirements are being referred to in the statute will just be the overall process through which claims will be made and handled and adjudicated if necessary by the division that will be in charge of handling the benefits. So I think the pointer there for businesses is that administrative requirements is to be determined. Stay tuned. The application, I think, is simple enough that this will be part of the administrative requirements. There'll be some form that an employee has to, fill out and submit to the division or to make a claim for benefits. And I imagine there'll be some kind of notice provision for employers and things like that. So stay tuned for that one as well. So let's take a look at the earnings requirements. So there are three ways to meet the earnings requirements here. The employee can earn either at least $2,500 in wages during the quote-unquote base period, and this is a term that's borrowed from the workers' compensation statute under the law, and the base period is defined as the first 4 of the last 5 calendar quarters preceding the first day of the individual's benefit year. So basically what that means, I think, for businesses is that if an employee has earned at least $2,500 during quarters 1, 2, 3, and 4, and then gets ill in quarter 5 and is not earning that amount of money, then the individual is still qualified for leave. Alternatively, there's the alternative base period, and that's defined as just the immediate last 4 quarters period. So we're not talking about the first 4 or 5, we're talking about the last 4. And then the final option for meeting the earnings requirement is if the employee elects into coverage under the statute that I have cited there. And again, the employees who be electing into coverage would be the self-employed persons and the local government employees who decide to opt into the program rather than just automatically being subject to the statute. All right, and let's move on to the next slide. So what is a serious health condition? Serious health condition is an illness, injury, impairment, pregnancy, recovery from childbirth, or physical or mental condition, and this is important, that involves inpatient care in a hospital or hospice or residential medical care facility treatment, or I guess I should say care there, or continuing treatment by a healthcare provider. I think the first two are pretty self-explanatory. If someone requires placement at some kind of facility, they're obviously going to become qualified for leave for suffering from a serious health condition. The one that gives me pause, and I think the one that should give businesses pause, is this last phrase here, where it says continuing treatment by a healthcare provider. No one really knows what that means other than the fact that they seem to be talking about chronic illnesses of one kind or another. What's not clear here is the severity of the chronic illness requiring leave. And I would imagine that this is the kind of provision that's going to result in some litigation, especially if there's no further clarification from the department with regards to what qualifies as a serious health condition. So again, like I said earlier, the regulations are going to be really important here. So, pay special attention to whatever regulations come out on this point in particular. All right, next slide. So family members. there are 5 definitions of family members, and I'll run through them quickly. First is children. Second is parents. And again, there's a number of different ways that people can be defined as children or parents. It's not just, biological children and parents. It includes things through adoption and through marriage and whatnot. So next slide. Spouses are also going to qualify as family members, as will grandparents and grandchildren. They're going to be family members as well. And again, this is through, whether it be strict biological relationship, through adoption, or through marriage. And then here's the big one at the bottom, and I want to talk about this one for a little bit. So people who are also family members include this last definition at the bottom, that is, as shown by the covered individual, any other individual with whom the covered individual has a significant personal bond that is or is like a family relationship, regardless of biological or legal relationship. So there are 2 things that I want to flag here that I think businesses need to be wary of. The first is this is an incredibly squishy definition. The definition is a significant personal bond. And so that can be pretty much any kind of person here. I mean, I don't think we're talking about pets. I mean, we're talking about individuals, persons. But this could be really good family friends, could be neighbors, could be a lot of different things. And how do we know whether there's a significant personal bond? Well, it's this first bolded and underlined phrase there in that definition, as shown by the covered individual. So what that means is that the employee determines who the, whether the person is someone with whom they have a significant personal bond. This is not really something for the employer to question. This is a very subjective test. And I think the practice pointer that I would give to businesses and to employers is that I don't know how you can reasonably challenge this. It's going to be very, very hard, because all the employee has to do is get up on the stand, raise his or her right hand and say, yeah, Bob was a very, very close friend of mine and was like family to me. And so I needed to take leave to go take care of him. Something like that. I mean, it can really be that simple. Now, if you happen to have good evidence showing that the employee is lying about his relationship with Bob, great, but I don't think that's going to happen very often. So this is a very tricky catch-all that employers need to be aware of here. All right, next slide. So earlier we're talking about beyond serious health conditions, qualifying exigency leave is also a condition for taking paid family leave under the Act. And qualifying exigency leave is basically military leave. So any leave related to military service is going to fall under this category. So next slide. Safe leave. Safe leave is roughly defined as any kind of leave relating to domestic violence, stalking, any kind of conduct that, for which the employee may have to go get a civil protection order. And there are just a couple things that I want to point out here for employers to be aware of. First of all, employees can seek leave if they're seeking a civil protection order. So that'd be that first bullet point there under safe leave. The second is they can also take safe leave if they need to get treatment for domestic violence that they've suffered. Basically, if they need to get like psychological treatment or physical health treatment for any domestic violence that they've sustained or abuse. And here's the important pointer here. This is a much broader definition of medical care than what you'll find under serious health condition. So we're not talking about serious health conditions anymore, or that level of treatment or that level of care that may be required. This is something else, and this is something that's far lesser. I mean, something as simple as, the employee just got out of an abusive relationship and they need to go talk with a counselor. That's going to fall under this kind of leave here, and the employer is going to be required to give them leave for that. let's see. The employees can also take safe leave if they need to set up security systems at their house, do things like that. And the employees can also take leave if they need to go chat with an attorney about any of these types of issues, anything domestic violence related, stalking related, things like that. So this is a very broad catch-all here. I think employers need to be careful with this one too. I can see it being very easy for employers to inadvertently violate the safe leave requirements just because it's not the kind of leave that we typically think about with more well-known concepts like FMLA and things like that. All right, next slide. All right, so we've talked about who gets to take leave. Let's talk about what the benefits actually are. So generally speaking, covered individuals are entitled to 12 weeks or up to 12 weeks of paid leave per calendar year. And this 12 weeks can be expanded up to expanded up to 16 weeks. So you get an additional 4 weeks of leave if you're a covered individual with a serious health condition related to childbirth complications and things like that. But otherwise, it's just 12 weeks. This next point here is incredibly important for employers to bear in mind. Leave does not have to be taken all at once. Leave can be taken incrementally and intermittently. And so what that means is that if the employee needs to take leave for some kind of serious health condition, and they just need to take like leave for an hour per day, once a week or once a month or something like that, then the employer is going to be obliged to work with the employee to actually provide them that kind of leave. And in fact, when you read the statute, it's very clear just how incremental leave can be. The leave can be as little as 1 hour of leave at a given time. And in fact, it can be even less than that if the employer is tracking the accrual of leave in smaller increments. So if you're an employer and you track leave, say, in 1/10 of an hour increments, I don't think anyone does that, but let's say you did, then you would be obliged to give your employees 6-minute 6-minute paid leave breaks, which is kind of absurd, but that's what the statute says. Okay. The one limitation here is that the employees who do take leave is that they are obliged to work with the employers and cooperate with the employers and provide notice with regards to their leave requirements. This is a little bit of a squishy concept, I think, and a squishy protection for employers under the statute. I'm interpreting as employees are obliged to work in good faith with employers. I don't think there's really any kind of penalty if employees are not particularly cooperative. I don't think the act goes that far as to set anything like that, but in theory, there is a requirement that employees cooperate. I do think that this is one of those areas where we may see additional regulatory definition from the state as they begin to build out this program. So next slide. So generally speaking, the amount of paid leave is, well, they have a formula here, and I put the formula there for people to pay attention to. I think the most important part of the slide is going to be the last paragraph, just so people understand the maximums available. The maximum is basically going to be 90% of the state average weekly wage. So even if you earn, say, like 3 times that amount, you don't get your full wage. You're only going to get 90% of the state average weekly wage. And the reason why I raise this is that this is an important valuation issue for self-employed persons to consider when they're trying to decide whether they want to opt into this program or not. It may be that it's just not worth your time and worth your money to opt into this program because you won't be paid enough of a benefit to make it worth your while. So just bear that in mind. I think the other thing to point out here is that you understand how what the cap on the benefits are or is, then it becomes clear that this is really kind of a tax on higher earning individuals too. It's the higher earning individuals that are really subsidizing this program, and we'll get into that a little bit further here when we take a look at what the premiums are and the true costs of the program are. So next slide. So generally speaking, individuals who do take leave get to keep all of their benefits with their employers. They will continue to accrue benefits at the same rate that they otherwise would. The only thing that stops accruing would be, oh, sorry, I take that back. The status quo that the employees get to keep would be their actual position. So they get to keep their wage, they get to keep their existing benefits, anything that they've accrued, and they get to keep anything that the employer has contractually given the employees. The only thing that stops, or the only things that stop during a paid leave period would be the accrual of seniority. Let's say there's some kind of seniority plan or something like that. That would lead to wage increases and whatnot. That stops. And then the other thing that stops would be the accrual of benefits because the employee is no longer working. So the types of benefits that would stop occurring would be things like paid time off in particular. I think that's the big one here. But other types of benefits like payment of health care, all that stuff stays in place when the employee takes leave. And then this last provision is incredibly important for employers. And I mentioned this earlier when we're talking about some of the individual liability issues. The Leave Act makes it unlawful for an employer to interfere with the rights that employees have under the Paid Family Leave Act. And in particular, what the Paid Family Leave Act does is it creates a separate civil cause of action that employees can bring against employers who violate this prohibition. And the long and short of it is that they're very heavy-hitting penalties. The statute expressly refers to employees having all of the rights of recovery that are present under FMLA violations. And those are not good if you're an employer being sued for an FMLA violation. I mean, that's going to include things like not only just like awards of back pay and other compensatory damages, but now you get into additional liquidated or punitive damages, if you will, plus awards of attorney's fees. If you're a member of the plaintiff's employment bar and you represent employees and you like to sue employers, you're really going to like this act. There's a lot of money that can be made here for the plaintiff's bar. So again, and I'll talk a little bit about this later, if you're a small business, definitely go chat with an attorney to make sure that you're in compliance with all this stuff so you're not creating big liabilities that you're not otherwise aware of. Because again, it's really going to be easy to get tripped up here. All right. So the other thing to know, and this is going to apply mostly to larger employers that provide a lot of benefits to their employees, is that there are coordination of benefits issues that are sorted out within the Paid Family Leave Act. So first and foremost, paid family or leave taken under this act is going to qualify as leave under FMLA, meaning that any FMLA obligations will be satisfied by letting an employee take paid leave under this act. The other thing the statute does is that the statute lets employers make it so that Paid Family Leave Act leave has to be taken concurrently with other types of leave that the employer provides as a benefit to the employees. These would be things like short-term disability policies, stuff like that. The important thing to keep in mind here, and I have this highlighted at the bottom, is that the employer has to give the employee notice ahead of time about this requirement. And so as long as there's something somewhere giving employees notice with regards to how coordination of benefits will be handled, then the employer gets to dictate kind of how they'll be handled. However, if the employer does not do this, then the employee probably will get to take a whole bunch of leave concurrently, meaning they'll take their leave under the Paid Family Leave Act first, and then if there's a short-term disability policy afterwards, they'll take their leave under that. And so the employer can get kind of stuck at that point. And end up having to provide a lot more leave than they otherwise might have to. All right, next slide. So this is also important. Employers may not require that employees use any accrued paid time off before using Paid Family Leave Act benefits. Now, that said, the employer and the employee may mutually agree that the employee can take the paid time off first before using those benefits. This is just something to keep in mind. And for those wondering why an employee may want to do this, the answer goes back to the limitation on the benefits that's allowed. And that is that if you're a high earning employee, you may want to just get paid for taking the time off that you need to take time off, as opposed to, get paid at your regular salary and compensation level, as opposed to taking the compensation that you would get under the Paid Family Leave Act. That's it. All right, next slide. So here's the butcher's bill for this thing. The premiums for this program are going to be anywhere from 0.9% of an employee's wage. At least that's where it's going to start anyway. And it'll go up to 1.2% of any given employee's wage. And then this will all be defined and handled by the division. Basically, the goal here under the statute is to have the division only collect as much money as is necessary to maintain the fund that is being created to administer the program. But one thing to kind of keep in mind here is that there are a lot of concerns right now that this program may already be underfunded. So there could be additional tax increases to handle this stuff. And if that's the case, then I think employers can kind of presume that the actual assessment rate is going to be at that 1.2% cap. But that's all that's going to be allowed right now under the statute. So next slide. So here's how that's actually going to be paid. We have three different categories of employers here that are going to be making payments into the fund. Employers with 10 or more employees have to pay 100% of that premium to the fund. So that would be 100% of the 0.9% or the 1.2% into the fund. And that 100% is paid for by the employer paying half of it, and then 50% of that being paid for by the employee. Okay. For smaller employers, these would be employers with fewer than 10 employees, they only have to pay 50% of that 1.2% or the 0.9% premium. And all of that can be deducted from the employee's wages by the employer. So really what we're doing here is we're creating an environment where we're trying not to put too much of a burden on small employers and not dump the premiums on them. And we're shifting the burden more towards larger employers. And then lastly, people who opt into the program, these would be the self-employed individuals. And then also, this will also apply for the local government employees that actually opt into the program. They simply pay 50% to the fund. So 50% of the premium. So that'd be half of the 0.9 or the 1.2%, whatever it is for a given year. So what does all this mean for employers? Let's go to the last slide here. I think there are a few big takeaways here. First and foremost, I think that small businesses need to start budgeting for increased labor costs that will be incurred beginning January 1st, 2023. And this is going to change the market. I know that for a lot of you out there, and I've talked with you about this, when you're already chafing a bit under the rapid increases in minimum wage in the state. And so this is going to be one more thing that you have to deal with. I know that restaurants that employ more than 10 employees are going to be particularly burdened by this regulation. So you'll want to start planning for this now. Next thing, I think the businesses need to pay attention to what's going on over at the Department of Labor to see what regulations are being passed. With regards to the new agency that's being created to administer this thing, it will be a sub-agency of the Department of Labor. I don't think it's been named yet, but it's probably going to be something like, the Division of Paid Family, Medical Leave, and Insurance Act, or something like that. So just check over there periodically to see what comes out. The last thing, and this is also very important, is do check with an attorney to make sure that your employee handbook or any other employee policies that you have are up to date. Like we talked about earlier, there are very severe penalties for employers who screw up and violate the provisions of the Paid Family Leave Act. I know that the program is really set to go into effect in terms of premium collection beginning 2023. with benefits to be paid 2024, but the statute itself is going to go into effect before that. And if you look at the way that the act is defined, you look at the way that the act is written, I do think that employers that provide paid leave benefits now for their employees are probably subject to the punitive provisions under the act, the punitive civil liability provisions. So you may be on the hook for the retaliation claims and other types of adverse claims that could be brought by employees beginning as early as January 1st of 2021. So make sure that you have all the right policies and procedures in place to mitigate the administrative and civil liabilities that this act creates. And with that, I'll open this up for questions.
I'm not seeing any questions, Mike. I think you either did a thorough job or you've kind of had other people like me who are, no, I yawned because I'm just so exhausted today, and Brian decided to comment about that. But anyways, for those of you that are hopping onto our broadcast, we have with us Mike Lazar. He's our general counsel to Westminster Chamber and several other businesses that kind of need that lending hand from an external source. He is an attorney in Denver, but also works somewhat remotely during this time of COVID. And I'm not going to try and say your firm's name because you've added a fourth one in there, and I had just barely gotten it on my own. So he has gone over what the family medical leave looks like structurally right now. Obviously, before the administration is created, that will populate a lot of the details that we need for our businesses to follow through. So I've tried my best to capture a lot of this into the comment section of the broadcast. Mike, is this PowerPoint something that we can make available to others that do want access to it or would like to
please do pass it around
directly?
to businesses. I've created this as a resource for people to rely upon. It'll provide kind of the most important nuts and bolts with regards to what's going to matter to employers and employees. There are some provisions that I didn't go into a lot of detail on in there just because I think it's kind of tangential at this point. Really what I wanted this presentation to be is something for small businesses to kind of start looking at this act and start wrapping their heads around what it means for them.
Absolutely. And I saw a lot of people that were on here with us. Nick Kleibenstein, I also see Larry, Denny, Jeff. We had all Brian's on here, Elizabeth, and several other people that were tuned into our broadcast. Thank you guys for spending some of your morning with us. Jeff's quickly commenting. He said, hello to Mike and Juliet earlier, and then he said he's learning something from you this morning. Thank you for that. Of course, Brian Dice is sharing a quick thank you as well for the information that you're providing to our business community. He did follow it up with, obviously, the need for our businesses to reach out to an expert or knowledgeable attorney like yourself that may need to analyze kind of their business itself and how to approach this as best as they can. Of course, referencing the state as they come out with new guidelines. I know Mike touched on a lot of state statutes that are in place, what those definitions look like and how they mean. I don't see any questions, to be quite frank with you, which is probably something that we had a lot of information on. And so people generally will digest, and we may get a couple questions later on. And so if you have any questions later on that you don't get a chance to ask us today, please comment it into the comment section or privately DM it to us. I'll be sure to get that to Mike so he can reach out to you directly. Mike, is there a phone number or email if you want folks to reach out to you on this?
So let me give out my office number. It would be 303-813-1200. I'm at extension 1027. And then the easiest way to get a hold of me right now, because our office is in COVID shutdown, so no one's there that frequently. You can reach me at mlazar@fncslaw.com. So that's M as in Michael, LAZAR at Frank, Nancy, Charlie, Sam, law.com. And again, don't be shy reaching out. And this is one of the things that I think this is one of the more important takeaways that I want small businesses to have from this presentation, and that is that when you look at this particular law, how it was passed, and the fact that it's really different from what we've seen previously come from the state. mean, this is a significant amount of state intrusion upon smaller businesses that we've not seen before in this state. And I mean, if you look at other paid leave acts, other statutes regulating employers to this level, I mean, really you're talking about larger federal statutes and other types of statutes that really only impact employers that have, you know, significant numbers of employees, say like 15 or more. This is the type of act that impacts every small business that has an employee. So I would encourage those types of smaller businesses to actually start thinking about what their HR needs actually are. I do think that businesses are going to need to start looking at getting some outside help and outside consulting to handle some of these issues. You don't necessarily need an attorney for everything, but you are going to need some help if you're a small business owner. And you know, just the amount of stuff that you're going to have to process is just too much for you to keep up with on your. I mean, you're busy running your business. Don't spend hours and hours and hours and days, you know, getting up to speed on some act like this. That's not going to make you money at the end of the day. So go get the help you need.
Absolutely. And we've included Mike's contact information, both his office line and his email, into the comment section of this broadcast. This video will be available to you at any point in time to rewatch, to share out to your network so folks can be in the know on what's going on, what this might mean for them, and where they can get access to resources and people that may be able to assist them further. We are, believe it or not, we're over our 30-minute mark, which unfortunately means I do have to wrap it up. But we'll be back here tomorrow at 11 a.m. And tomorrow's broadcast is focused around hiring, workforce, and some things to keep track of and kind of best practices during COVID, during the holiday months, and kind of just proactively being a small business owner, considering best hiring practices for temporary workers and others. So please do tune in tomorrow at 11 a.m. to our broadcast. And thank you so much, Mike, for being a part of our presentation today. I enjoyed it. I know I am exhausted, but I did enjoy your presentation tremendously this morning.
Thank you. It was fun as always.
Always.